their advice. The President of the United States can dismiss any secretary at any time. The President of the Indian Union has no power to do so long as his ministers command a majority in Parliament. Federalism. Two principal forms of the Constitution are known to history. One is called unitary and the other federal. The two essential characteristics of a unitary constitution are: 1. The supremacy of the central polity. The word polity means system of government or political organization. And second, the absence of subsidiary sovereign polities. Contrariwise, a federal constitution is marked by the existence of the central polity and subsidiary polities side by side, and by each being sovereign in the field assigned to it. In other words, federation means the establishment of a dual polity, that is, dual system of government, central and state. The draft constitution is federal constitution in as much as it establishes what may be called a dual polity. This dual polity under the proposed constitution will consist of the union at the center and the states at the periphery, each endowed with sovereign powers to be exercised in the field assigned to them respectively by the Constitution. This dual polity resembles the American Constitution. The American polity is also a dual polity. One of it is known as the federal government and the other states, which correspond respectively to the union government and the state governments of the draft constitution. Under the American Constitution, the federal government is not a merry league of the states, nor are the states administrative units or agencies of the federal government. In the same way, the Indian Constitution proposed in the draft constitution is not a league of states, nor are the states administration units or agencies of the union government. Here, however, the similarities between the Indian and the American Constitution come to an end. The differences that distinguish them are more fundamental and glaring than the similarities between the two. The proposed Indian Constitution is a dual polity with a single citizenship. There is only one citizenship for the whole of India. It is Indian citizenship. There is no state citizenship. Every Indian has the same rights of citizenship, no matter in what state he resides. There is another special feature of the proposed Indian Federation, which distinguishes it from other federations. A federation being a dual polity based on divided authority with separate legislative, executive, and judicial powers for each of the two polities is bound to produce diversity in laws, in administration, and in judicial protection. Up to a certain point, this diversity does not matter. It may be welcomed as being an attempt to accommodate the powers of government to local needs and local circumstances. But this very diversity, when it goes beyond the certain point, is capable of producing chaos and has produced chaos in many federal states. One has only to imagine 20 different laws. If he have 20 states in the union of marriage, of divorce, laws of inheritance of property, family relations, contracts, torts, crimes, weights and measures of bills and checks, banking and commerce, of procedures for obtaining justice and in the standards and methods of administration. Such a state of affairs not only weakens the state but becomes intolerant to the citizen who moves from state to state only to find that what is lawful in one state is not lawful in another. The draft constitution has sought to forge means and methods whereby India will have federation and at the same time will have uniformity in all basic matters which are essential to maintain the unity of the country. The means adopted by the draft constitution are three. First, a single judiciary. Second, uniformity in fundamental laws, civil and criminal. And third, a common all India civil service to man important posts, a dual judiciary, a duality of legal courts, and a duality of civil services are the logical consequences of a dual polity which is inherent in a federation. In the USA, the federal judiciary and the state judiciary are separate and independent to each other. The Indian Federation, though a dual polity, has no dual judiciary at all. The High Courts and the Supreme Court form one single integrated judiciary having jurisdiction and providing redeems in all cases arising under the constitutional law, the civil law, or the criminal law. This is done to estimate all diversity in all remedial procedures. Canada is the only country which furnishes a close parallel. The Australian system is only an approximation. Explanation. In some federal countries, the Supreme cannot overrule the judgments of the state courts relating to laws of the state. However, in India, the Supreme Court can hear appeals against the decision of any court and give judgment. Care is taken to eliminate all diversity from laws which are at the basis of civil and corporate life. The great courts of civil and criminal laws, such as the